The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday, the 13th of May, 2016, are currently trading with gold at $1,272.40 an ounce, silver $17.10 an ounce, Texas crude $46.70 a barrel, and Bitcoin is currently sitting at about 457 U.S. currency. Today in history, the year 609. Pope Boniface I turns the Pantheon in Rome into a Catholic church. It was given to the Pope by the Byzantine Emperor Phocas. Pope Boniface then ordered that the church should, quote, be made to the Holy Virgin Mary and to all the martyrs, so that the commemoration of saints would take place henceforth, where not gods but demons were formerly worshipped. The rebranding of the Pantheon, today in history. In recent news, the Obama administration suggested today that public schools across the United States let transgender students use the bathroom in locker rooms that corresponds to their gender identity. The statement issued just days after the Justice Department and North Carolina mutually sued each other over their state law requiring transgender individuals to use a public bathroom that corresponds to the gender on their birth certificate. And though this push from the White House is not legally binding, since this issue has not yet been definitively answered by the courts, schools that refuse to comply could potentially be hit with a civil rights lawsuit from the government and even face a cutoff of federal aid to education. Texas's Lieutenant Governor Republican Dan Patrick said that the state is prepared to forfeit billions rather than to let the Obama administration dictate restroom policy for its 5.2 million students. Many other governors and state legislators have voiced similar concerns, calling this a blatant overreach of executive powers. At BMW's annual shareholder meeting yesterday, BMW chairman of the board, Harold Kruger, detailed BMW's next innovative flagship, iNext, an autonomous, intelligent, lightweight electric car, a combination of BMW's electrified i brand and the Vision Next 100 concept car that debuted with the company's 100th year birthday. This sci-fi ride will be BMW's answer to the growing number of high-tech luxurious electric vehicles, running up as the major challenger to Tesla. The Lone Star Lowdown is currently looking for sponsors. If you have a product or service you'd like to advertise with us, feel free to give me a call at 210-363-2257. It's been Rick Rohde with your Lowdown for May 13th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father. You chuck it on
okay, howdy, this is Randy Kelton, Vet Pack, on this Friday the 13th, May the 13th, 2016. I don't know if Fridays are supposed to be bad luck or not, but I've had pretty good luck here lately, and this Friday hasn't hampered it much, except for Vet's there in the background, and she's having a little technical difficulty. We can hear her. She can't quite hear us yet, but we should have that up here shortly. I'm going to start out going through another section on the ebook that I'm working on. There, in doing the show that I've been doing for several years and addressing issues people have, there are some truths and understandings that have worked themselves out from between the cracks. And these are the things that, for the most part, you're not taught in civics class. I keep getting reminded of that passage from, I think it's Kodachrome by Paul and Simon and Garfunkel, where he says, after all the crap I've learned in high school, it's a wonder I can think at all. Well, if you pay attention to what they tell you in civics class about all these great and wonderful rights you have, they give you the impression that these great and wonderful rights are just automatic and everybody out there is there for the purpose of protecting and securing your rights for you. Forget about that, because, and we all know that because we spend 12 years in a government-mandated school system. We don't choose it. We are required by our government to experience it. And while we're experiencing this government-mandated school system, we're told about all the great and wonderful rights that we have. But at the same time, it is made very clear to us, don't you even imagine trying to exert those rights while you're in this school. Because if you do that, the whole weight of the system will land right square on your head. So we put our children through 12 years of government-mandated school system. And then we let them out here in the real world. And for the most part, people don't have anything to do with the public officials anymore. Until they wind up being subjected to our courts, either criminal or civil. And the first time someone's drug into court, or the first time someone files a suit in court, they will get a whole new education. And for the most part, they will have no clue as to what's coming at them. And most people feel frightened, intimidated, and betrayed. And these three combinations tend to cause people to want to avoid these systems at all costs. That's part of the reason our public officials in the criminal justice system has been able to achieve a 99.6% conviction rate. Everybody takes the deal because the system has been designed to force you into a position to where a reasonable person of ordinary prudence has no reasonable option other than to take the deal. And civil is not much better. We expect these judges to be fair and just. And that is just absolutely wrong-headed. From the very beginning, our expectations are just simply wrong. And last week, I started out talking about some of the common fallacies. And I won't go into those this week. I may do that again in another week or so. But here I'm going to talk about stuff they don't teach in law school or in high school, civics class. And to start with, if you're to have a chance in court, you're going to need to understand how the courts really work and develop some methodologies that will allow you to maneuver through their complex system. Well, the court system is complex. It's not beyond understanding because it is consistent. And last week when I talked about going to court and expecting the judge to be fair, do not expect the judge to be fair. Do not expect the judge to be just. We don't want our judges being fair and just because that implies that they get to juxtapose their concept of fairness and justice on the rule of law. I want that judge determining the facts in accordance with the rules of evidence, applying the laws that comes to him to the facts in the case. I am not interested in his personal perception of justice. That's what we had in the common law. And this country fixed that. There's no more of that common law nonsense where a judge can rule any way he wants to. We wanted him bound by statute. It is not the judge who is there to bring justice. It is the legislature. It's their job to so design the laws so that they result in the just adjudication of cases. So I want that judge to follow law, and I don't care what his opinion is about it. Well, that's a primary fallacy. And once we understand that part, then we go back and look at how the system is really, how it actually works. The system was not, from the judge's perspective, is not intended to be just, but it's intended to be consistent. And in the overall scheme of things, consistency is what we need. Now, if the law brings an inconsistent or unjust outcome, then we need to go to our legislators and have them change the law to fix whatever problem it has, and then we have our judges enforce the law the way we enact it. In the real world, though, lawyers and judges do whatever they want unless they're called on their behavior. Lawyers and judges they pretty well control their system. I mean, if you're a mechanic and somebody brings you a car and you get somebody like me that thinks he knows something, then you got that guy coming out there telling you what you should do when you know what you should do. You want to say, go away, leave me alone, let me do my job. Lawyers and judges, when they deal with their clients, they want you to leave them alone, let them do their job. And that would be okay if we had adequate checks and balances, but we don't. It would be okay if we didn't have so many lawyers that lawyers are put in a position to where they have to create litigation when it's not necessary because they need work. We're graduating 40,000 lawyers a year. The United States has more lawyers per capita than any other country in the world. That's part of the reason we have a 99.6% conviction rate and why this country is the most litigious country in the world by far. We as potential pro se litigants, or even as litigants with a lawyer, we need to understand these facts about how the system really works. So this is the primary position to come to the courts from, is that the courts are not there to serve your interest. They're there to serve the interests of the judges and the lawyers. Now we get the part, this kind of goes to what they don't teach you in law school. When lawyers go to law school, it generally costs, I've talked to lawyers, and it costs between $150,000 and $200,000 to get a law degree. And a good portion of these lawyers will have $150,000, $180,000 student loan to pay off. They got to get here and make some money. Now, when they go to law school, I'm sure that they went to law school because they wanted to be like Perry Mason. They wanted to be able to help people find justice. But when they get out in the real world, they find they got to make money. And the profession of lawyer is a profession. It's their job, and they need to get paid for their job. So they're not going to do anything to jeopardize their ability to make money. And that certainly includes not doing anything to annoy that judge. Okay, the whole system is about money. The lawyer very quickly learns that he is a salesman. First and foremost, he's got to bring in clients. And the unfortunate part about that, there are so many lawyers, and they're struggling so hard to get clients. They spend most of their time trying to get clients and a very small amount of their time adjudicating cases. What they wind up doing is specializing in very finely honed areas of law. So in this area of law, they have all the motions and pleadings that they use in these cases. They've already got them in their files. So almost anything that normally comes up in the adjudication of your case, they've already got their motions in there and their pleadings and their responses to the other motions, because the other guy's going to file the same thing all the time. They're going to file the same responses back and forth. And this is what winds up happening. And it's worse. The very worst place is family law. And it's a good example. You got two people that are very angry at each other, and they go see a lawyer. And the first thing the lawyer wants is a retainer. Now, that's what he really wants. He gets that retainer, and he's got these standard little things he does and to use up your retainer. And in family law, they get past the retainer. Generally, you get a lawyer and you tell him about your case, and he tells you, oh, yeah, you got all these claims. You can do this, that, and the other. You give him your retainer. When he uses up your retainer, then he comes to you and he tells you the real deal. Then, for the most part, he wants to get rid of you, and I'll explain why when we come back. Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number 512-646-1984. I'm opening up the phone lines. We keep them open all night, so give us a call, question or comment. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
On the edge of a hole, inside a deep dark bowl, I'm always on the lookout for something to soothe my soul. So I sit back and I watch the evidence unfold, and I see justice.
We are back. You're listening to Rule of Law with Randy Kelton and Vet Pack.
Rule of Law Radio on this Friday, the 13th, May the 13th, 2016. And we're talking about what they don't teach you in law school. And when I went out, I was talking about why a lawyer, once he uses up your retainer, wants to get rid of you. The reason he wants to get rid of you is once he's used up your retainer, now he has to go to work. Now he's got to get busy and actually try to adjudicate your case. And lawyers don't like adjudicating cases. They don't like doing legal research and filing motions and pleadings that they haven't filed 100 times before. And the reason being is they are learned counsel. Being learned counsel, they cannot make mistakes. They can't misargue a law or case law. They can't bring a case before the court that has been struck down by another judge or by a higher court. It may have been good case law at one time, but it's been distinguished or it's been overturned. If he brings something like that, then if the judge accepts his case law and it goes to the Court of Appeals is going to come back and smack the judge for relying on antiquated law or relying on a improper argument. And when that happens to the judge, he's going to be a really unhappy camper. And he's going to come back and land on that lawyer like a ton of bricks. So lawyers really don't want to do what they don't do every day because lawyers are terrified of judges. A judge can sanction a lawyer on a whim. And the lawyer can try to fight the sanctions, but for the most part, he has to pay him first. And a judge can sanction a lawyer for anything he wants to. So judges are in a position to where they can act arbitrarily and capriciously when it concerns lawyers. And there's little or nothing the lawyer can do about it. So lawyers are terrified of judges. They're terrified of coming up with motions and pleadings they haven't come up with before. So they got this set of things they do. And they charge you a retainer, and then they have a flurry back and forth of these standard documents that everybody does all the time. Family law is the worst because the two lawyers get together and they take a look at the couple's estate. And they try to estimate how much of that estate they can swallow. And then they do their best to set these two litigants at one another's throats so that they're willing to give these lawyers every dime they've got, every dime they can beg, steal, or borrow in order to get back at the party on the other side. And the lawyers are just sitting back there raking in the bucks. And when you run out of money, they're going to throw you under the bus and go to the next client. They're in business. They're not here to help you out or find you justice. They're here to make money, always here to make money. And if you're going to use a lawyer, you need to understand how to control your lawyer. And we've got the call board's filling up really fast, so I'm not going to spend much more time on this today. If we run out of callers, I'll go back to it and bore everybody to death. Okay, we're going to go to our call board. We've got Leslie in Pennsylvania. Hello, Miss Leslie.
Hello, and how are you?
Miss Leslie, I have your pleading. Leslie has been fighting these guys for how many years now, Leslie?
Since 2010.
Since 2010, 6 years. And you filed a notice of rescission, and at the time you were current on your mortgage. Is that correct?
Yes.
So, and he's been fighting this issue the whole time. Now, you kind of give us a synopsis of how you got to where you're at now.
Well, when my husband, where he was working closed down, they were going to give him his pension in one lump sum. So we wanted to find out from our mortgage company how we could pay this off before we retired, and we wanted some more information, and they would never put me through to customer service. They said I had to be 90 days behind before I could talk to anybody. And my credit score was very high, and I didn't want to take those chances, so I started looking for other options. And we decided that if we put in for a rescission and they came back and wanted the money to pay, they'd still have to prove up who they were, so we'd be paying the right person, and we had the money to pay them all up front anyway. Then I read the law a little more carefully, and it showed that you had to pay the value of the property, not the value of the note. So after we filed for rescission, and they never answered, and first we filed a notice of intention to rescind in 10 days. We gave them 10 days, or 20 days, I'm sorry. We will cancel in 20 days. In 20 days, we sent them a notice of default, and 6 months later, because we hadn't heard anything, we sent them a final notice. Now, all this time, we were paying them. But when we sent in the last one in the 6 months, that paid off everything that we would have paid had they come and given us all the money we paid them and the value of the house. That would have settled the account. You understand what I'm saying? So we're not in default now. We're all caught up. Everything's paid. They just haven't canceled the mortgage yet. But they came after us for foreclosure. We had filed to enforce rescission in the federal court, and in that we found out who owned the mortgage and who did not own the mortgage. And then I filed for quiet title against the original lender because they were the only one in the county records. They never assigned the mortgage to anybody. So when we found out that Fannie Mae owned the mortgage and they were not going to put their name in the county records, we just filed for quiet title. Well, in the middle of that, there was an assignment made, but it was made from the original lender to City Mortgage. Now, when they did that, I accused them of fraud because City Mortgage had been saying all along, we don't have any interest in your mortgage. We want out of this. And then the next day, in court, after they went to court, the next day, the assignment of mortgage was created from them to City Mortgage. So I charged them with fraud. You know, I amended the complaint. I did everybody was full fraud and all that kind of stuff. So they came back and said we had nothing whatsoever to do with the assignment of mortgage dated September 20th, 2012. So now I had a list that was adjudicated in federal court of the chain of title. I had a legal document in court by the assigner of the mortgage that they had nothing to do with it. And plus, when I go on the website, I find out Fannie Mae still claims they own the loan, even 6 years after they assigned it, or 4 years after they assigned it. They still have it on their books. So when we filed the quiet title, the court threw it out. The appeals court threw it out because I did not put my husband in the quiet title action, and there was a reason for that. But it was not a legal reason; it was a physical reason because he wasn't able to be there when we had to go to court. So when they threw it out of court, before we got out of the Court of Appeals, the mortgage company filed for foreclosure on us. And now we're going round and round. I filed preliminary objections. The judge just said denied. Didn't say why, none of that stuff. So when they demanded I file a response. I filed a response, and I got preliminary objections from the opposition. So then I filed another response and got more preliminary objections. And we filed all these things back and forth until finally the judge said, everything for the plaintiff is what would you call affirmed. Everything is denied as to the defendant. So now they put in a motion for summary judgment, and we're in the Court of Appeals on the decisions that the judge has already made.
Okay, hang on. We're about to go to break. Randy Kelton, Vet Pack. We'll be right back.
The U.S. military is planning to implant soldiers with microchips under the guise of keeping them healthy. I'm Dr. Catherine Albrecht. In a moment, I'll tell you why that bad idea is a dangerous step toward a total surveillance society.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
10 Hut, you soldier, hold out that arm. It's time for your implant. Forced microchipping of American soldiers? Shockingly, that's apparently on the military's to-do list, to implant all soldiers with microchips so their health on the battlefield can be remotely monitored. Never mind the fact that implanted microchips cause illnesses like cancer. There are other reasons to oppose this awful plan. No American, soldier, teacher, cop, or criminal should ever be forcibly chipped and tracked, no matter how good the government says it is for us. If we allow this to happen to our soldiers, it won't be long before they come for the rest of us. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay,
we are back Randy Kelton, Vet Pack, Blue Law Radio, and we're talking to Leslie in Pennsylvania. Okay, Leslie.
Now we're facing a motion for summary judgment. I filed preliminary objections because we never got served with the motion for summary judgment. And we got it filed. They filed it the same time that we filed our motion, our appeals in the appeals court in Philadelphia. So when I filed preliminary objections, they objected. They filed opposition saying it's not proper to file preliminary objections to a motion of summary judgment. I said, well, it's no more proper than not serving the defendants the motion for summary judgment at all.
So your preliminary judgment, your preliminary objection went to service.
Yes. Well, no, I didn't. I said that we hadn't been served, but I'm going to put this in the court. You know, I object to the whole thing. There is no jurisdiction in this case. There cannot be. You've got a forged assignment of mortgage by 5 counts. You have a lender that is not included in an indispensable party, and by law, they are required to dismiss this case immediately when that's brought up.
Is this in a state or federal court?
This is state.
Oh, you really need to sue the judge in the federal court.
I've already started with judicial conduct complaints.
This is procedural due process violation. This is beyond scope. Mm-hmm. When you made a challenge to subject matter jurisdiction ceases to exist. The judge may not presume it. He must prove it. The judge must prove it, not the opposing party. You put the judge on the dime with this. And if the judge attempts to do anything after the subject matter jurisdiction challenge has been filed and before subject matter jurisdiction is proven, he is outside scope.
Exactly.
The only thing I know of you can sue him for directly is subject matter jurisdiction. You can always sue him.
Oh, yeah.
So you might consider filing suit against the judge in the federal court.
Definitely, yeah.
And you might also consider criminal charges with the U.S. attorney. Now, if you file criminal charges against a federal judge, like I'm about to do, they're going to do everything they can to fight you. But when you start fighting against state officials in the Fed, that's a whole other animal.
Yeah, because everything that I have brought into the court, I have said you have no jurisdiction. Every pleading I put in there, every single one, says this court has no jurisdiction. I work it in, just like you've seen in this pleading that I sent you today. That's the response to the objections of the plaintiff. But I always put that in there. There's no jurisdiction. There cannot be. Number one, it's rescinded. I sent in, when I put in the preliminary objections to the complaint, I sent in the Jesenowski decision, the entire thing, attached it to my response. They just out the window.
Well, this...
Like I said, if we considered anything, the plaintiff tried to say that defendant's allegations have been considered and rejected by the court. No, they were not considered by the court, or the case would have been dismissed. They were rejected out of hand, which is different.
So go after him criminally.
I intend to.
He may, I'm not sure what's going on with this judge. He may be bought and paid for, but I doubt that he's been paid to spend time in prison or been paid to wind up being a scapegoat that the U.S. attorney can use, especially during election year.
Absolutely.
To show that he's going after these right-wing, conservative, big-money scoundrels who's picking on the poor, ordinary citizen. This is exactly the kind of thing that in an election year the U.S. attorney is likely to pick up.
Oh, yeah.
In the end, it's all political.
Yeah. Because, like I said, we filed a judicial conduct complaint already with the Supreme Court. They had their board that investigates all that kind of stuff. But now that we're in the appeals court, do I have to wait until my case is finished? Or can I file charges now?
These are crimes. He's committed a crime. This judge is not the judge. That's your position. He's not a judge in this case. He's committing one crime against me after another. I don't just have to sit back and tolerate it. And you have a duty to give notice of crime. That you absolutely don't have to wait on. And I don't know of any reason why you couldn't sue the judge if he's lacks subject matter jurisdiction. He's not a judge, and that's your position. Since he won't adjudicate the issue, see if you can get a federal court to adjudicate the issue.
Yeah.
The Supreme just ruled on Jasanowski, and you come back with a case that mirrors Jasanowski. This judge is thumbing his nose in the face of the federal Supreme.
Exactly. Did you see how I put that out so that it's like 1, 2, 3, 4, 5? Here it is. They're the
yes, I was reading Leslie's document here, and I aspire to be able to write this clearly and concisely. She does really nice work. So this is much better work than I see from lawyers. The only time I see work this good is in court opinions, and generally federal court opinions. They tend to be well written. And this is a compelling document. It makes really damning claims. This should be in the hands of a federal court. The federal courts, they don't. The federal courts and state courts, the rule is go after the state and the Fed and the Fed and the state, because they tend not to be on the same side. And if there's a good old boy network, they don't tend to extend from the Fed to the state, and especially in an election year, because in the end everything's political.
Oh yeah.
And haven't you already written a RICO suit?
A what? Oh, yeah. They dismissed it.
Did you file it in the Fed or the state?
Federal.
And they dismissed it?
Federal. Yeah, with prejudice. But I talked to a lawyer friend of mine. He said, don't worry about it. We'll take care of it later. Just let's get this foreclosure stuff out of the way, because he's taking care of my appeal. So he's waiting till that is done, because we have other ones that want to join that suit. We have other, and because a lot of the same lawyers are involved. And there was like 17 different people in that as defense.
Okay, what was the reason for dismissing with prejudice?
Well, because we had filed the court. I couldn't understand it really, but it was because they said that we filed in the court, in the federal court earlier against City Mortgage. So I don't know whether it's with prejudice against City Mortgage only, because they're the only ones I ever filed against in my life. As far as in the federal court with City Mortgage, they were in the RICO suit. The RICO suit was all mostly attorneys, except for City Mortgage.
I would very much like to see the order in that case.
Yeah, well, I'll get it to you. I'll get it.
Okay, because to dismiss a fairly extensive RICO suit with prejudice, have you appealed that? No, I wasn't going to, because I wasn't ready to. My head's in such a whirl with this other stuff going on that I don't know. Maybe I jumped the gun on it too fast. You know what I mean? Because there's so many different. What would you call it? Defendants, and I was so busy with this other case, and I have 3 other foreclosures I'm overseeing. So it's been kind of tough on me. I understand this, and that's one of the things they count on is attrition. Because they just want to pound you down until you can't fight them anymore. But as well constructed as your documentation is, I'm surprised that we'll be right back. Okay, we are back. Randy Kelton, Vet Pack, Boulevard Radio, and we're talking to Leslie of Pennsylvania. This is kind of disturbing, is because your documents are so well constructed that they would dismiss the RICO with prejudice. This is really surprising and distressing. And you say there are other people picking up this RICO action?
There are other people that want to join it, yeah, because a lot of them have the same attorneys. There was 3 different law firms, and there was 3 different attorneys that different ones had in their case that they wanted to go after them because of the fraud.
Well, how does this dismissal with prejudice affect your position?
The lawyer said it doesn't.
Okay, so it was probably dismissal with prejudice only against the particular entity, and if I understood what you were saying right, it was probably because of res judicata.
Yes.
Okay, so that won't affect all the other claims. So your case wasn't completely thrown out there.
The orders. Yeah, I'll have to send it after. He said we can refile it at a different time because I wanted to dismiss it without prejudice for the reason that I was swamped. And,
yeah.
I made it clear to the court that I did want to revisit this. I did want to come back and file again. And he said no. But the lawyer said different. So.
Okay, so he probably knows how you can get around it. Well, that's better. But it'll be, you have one in the Pennsylvania Supreme. It'll be interesting to see what they do.
Yeah.
I have seen work from the Pennsylvania Supreme, and I was surprised. I had a guy who filed a traffic case and took it all the way to the Supreme, and he did a horrible job. He filed a 20-page certiorari with the Supreme, and they returned a 30-page explanation of what all he had done wrong, what he needed to do different to correct it so that he could refile to get a proper adjudication. I was astounded. They didn't just throw it out. So if that's any indication of the quality of the Supreme in Pennsylvania, you may actually get a good hearing.
Oh, yeah, I hope so. Well, this judge, I'm telling you, my papers are very clear. I mean, my claim is very clear. The rescission, I don't know how he can think he can adjudicate a rescission that's 6 years old. For one
yes.
I mean, hello?
this should, by the time this gets to the Supreme is almost certainly, the Federal Court of Appeals is almost certainly going to land on him like a ton of bricks because Jasanowski was so definitive.
Yeah.
That the judge is going against this. That's why I'm thinking, go after the judge. I'm doing that here in Texas. I filed a state quiet title action. The lawyer removed it to the Fed. I objected based on the 2011 Venue and Removal Clarification Act. That while it said that a case could be removed to the state, what the Clarification Act went to is there were some circuits who were saying that if a case with state issues and a federal issue over which the feds have exclusive jurisdiction, it can be removed to the Fed. And under judicial economy, the Fed could hear both the state and the federal issues. Well, there are other circuits that said, no, we can't do that. That's an unreasonable intrusion on state sovereignty, that we have to sever the state issues and send those back to the state. Well, in 2011, the legislature stepped in and they sided with the latter. They said, while the case can be removed, the state issues must be severed and remanded. So the way I read that is the legislature said the Fed does not have subject matter jurisdiction over state issues. So instead of filing a motion to remand once he removed it to the Fed, I filed a challenge subject matter jurisdiction. Claiming that the court could not hear any issues in this case, as the only issue in the case was quiet title. And the court couldn't hear a quiet title case because that's a state issue. So the other side, after I filed the subject matter jurisdiction challenge, filed a Rule 12 motion to dismiss, and the judge dismissed with prejudice. And this was a rescission act. He said, rescission doesn't last forever. And I said, yeah, it does. Once there's a notice of intent to foreclose, and you can show more than $35 on false fees, yeah, it lasts forever. There's no state statute of limitations on the right to rescind after foreclosure. So he ignored that part. That was the specific argument, and he ignored it and dismissed with prejudice without hearing my challenge to subject matter jurisdiction. Gotcha. Every case I've filed, he's dismissed with prejudice. Just out of hand. I'm sorry, except for one. I told Brett McClung, he was the attorney for Chase, what I intended to do. He filed the first one and removed it. I filed a challenge subject matter jurisdiction in that one. He filed a second one, and I told him that the judge dismissed the first one with prejudice. He filed the second one, removed it, and I told Brett McClung, said, it's not a problem. This is the lawyer for Chase. Said, I'm going to get this judge to do me a couple more, and I'm going to take him to the state grand jury. And this judge is a real stinker. Lawyers all hate to get in front of this guy because he's 89 years old, and he's just way out there. He is the meanest, nastiest judge you could ever come in front of. And I'm not a lawyer, so I don't care. So I told him I was going to file criminally against him. And I think he told the judge, because the judge did not dismiss the second one with prejudice. He didn't dismiss it at all at first. And then he ordered a scheduling order conference. And I told him, heck with that. You don't have subject matter jurisdiction. You have no power to demand a scheduling conference. Well, he dismissed without prejudice on that one. Now he's got the third one, and this one I had. The other times I filed a remand, but this time I filed a challenge to subject matter jurisdiction directly. He ignored it, ruled on the Rule 12 that came in after the subject matter jurisdiction challenge, and I got the ruling from the judge the same day I non-suited the case. Or he issued the ruling the same day I non-suited the case. He has a problem. The reason I non-suited is in the Rule 12 motion. He did a bunch of huffing and puffing about Hope Atila Respa not applying and out of time and blah, blah, blah. The second half, he claimed that Wells Fargo was not the creditor. Say what? They're trying to foreclose, and he puts in the document that they're not the creditor. So, Leslie, what do you do when he puts that in there?
You bless God.
You non-suit immediately. You don't want to give him a chance to fix his mistake.
Yeah.
Now I got him on collateral estoppel. And I had some guy out of Florida, this Bob Hurt. He was putting out some emails about how I've been drinking the Kool-Aid and how I'm getting thrown out of court. Well, it wasn't exactly like that. And I tried to explain it to him. All you want to do is, this is one of these guys that wants to talk about how stupid everybody is but him. And he just couldn't wrap his head around it. He didn't understand collateral estoppel. Collateral estoppel, for those who don't know, is where you come to court and take a position, like in your case, Leslie, where Citibank says that we don't have anything to do with this note. That's it for Citibank. They can never come back and say they do have something to do with the note, even if they do. Because they stated in court they don't, they're collaterally estopped from taking a different position. This lawyer said that Wells Fargo was not the creditor. So if I screw up and he realizes what he's done, he has an opportunity to file an amended Rule 12 and take that out.
Right.
So I was afraid he'd figure it out, and I filed a non-suit right away.
That's the best thing. Get it out of the court so it's on the record.
Yeah, he gave me a present. Thank you. So,
well, in this case, go ahead.
Now this is a perfect case to go after the judge with. Yeah. Because it's really clean. I'm not saying that he gave me a ruling I didn't want, because I non-suited. The same day he issued the order, I filed a non-suit. So I wanted the case to end. But it doesn't matter. I had a challenge subject matter jurisdiction in. And it's like when the clerk wouldn't show me the records and I called 911, and then she came out with the records. Sorry, Bubba, that bell's already been rung. The fact that I wanted this thing out of the court is irrelevant. The judge purported to exert an authority he didn't have, and under 18 U.S. Code 242 and Texas Penal Code 39.03, that's a Class A misdemeanor.
Randy, we're going to have to take a break.
All righty. Hello, Miss Vet. Will you bring us out?
All right. You're listening to Rule of Law Radio with Randy Kelton and Vet Pack.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
Welcome back. You are listening to Rule of Law Radio with Randy Kelton and Vit Pack. We are talking with Leslie out of Pennsylvania. Randy, do you want to go ahead and continue? Randy, are you there?
My bad. I forgot to unmute you, Miss Leslie. You can send me some sharp and pointed emails to let me know what a bad boy I've been. I was telling Vet on the break, this is Miss Leslie, the bad grandma. You do not want her after you.
No, you don't. A big bad grandma.
Okay. We have this opposition. Where are you from this point?
Okay, this is going to be filed on the 19th, which is next week. And in the conclusion of it, basically, I said the court must have dismissed the opposition of the plaintiffs to the preliminary objections and the motion for summary judgment and this action in foreclosure due to lack of subject matter jurisdiction. There is no enforceable mortgage or valid assignment of enforceable mortgage, no joint indispensable party, no proof of plaintiff's equitable interest in the mortgage, and is all required for jurisdiction for foreclosure. Only a forgery and counterfeit copy of the note prove any interest whatsoever in this action. There has not been any proven jurisdiction of this court in this matter. The Court of Appeals will not find that differently, nor would the Supreme Court of the United States. How's that? Are you there?
I'm always impressed with your pleadings. Well, a lot of pro ses, we get into talking about what we think is right and what we think is wrong and what's just, and you don't do any of that stuff. You go right to point of law, and you stay with point of law.
They don't care how you feel about it.
Well, yeah, they don't care, right? And you don't make proactive statements of law out of your own mouth. All of the things I talk about on this show about how to write good pleadings, you already do that. So I read your pleadings and figure out how you did it, and then I talk about it on the show and pretend like I figured it out.
It's so horrible.
Okay, so you're going to file this the 19th?
Yes. Mm-hmm.
Oh, wonderful. I'd be interested in seeing how the other side responds to it.
I don't know if they can, because this is an answer to their opposition, and I think that's the end of that. It's just...
Hold on. My bad. I thought this was an original pleading. Reply to plaintiff's opposition to defendant's preliminary objections to motion for summary judgment. Oh, so they don't get a reply unless the court authorizes it.
Yes.
So this is good. You get the last word.
Yeah, I like that.
Okay. Do you have anything else for us, Miss Leslie?
Well, I have a couple of things. One quick point is this judge never read any of the pleadings that I put into the court previously.
Oh, man, that should get...
judicial conduct complaint to make sure he read it, because I sent it to him.
Wait, say that again. Can you establish affirmatively that he didn't read it?
Well, when you read his orders, you can read that he didn't actually understand anything that I put in there.
Okay. I've been researching procedural due process because we keep having these judges take a portion of the pleading and address it and then ignore everything else.
Yeah.
And reading about procedural due process, you have a right to adjudicate your case, and the judge has a duty to address every claim that you make. If he steps over one, then he's denied you in your right to petition the court for redress of grievance.
Exactly.
That's a procedural due process, and that's a crime.
Good.
Nobody goes after the judges criminally. Lawyers would never do it because they're terrified of them. But in this case, do you still have a lawyer?
I do have a lawyer. He's a very good friend of mine, and he's taking care of my appeal for me.
Oh, okay. Well, I was going to say, if you have a lawyer, you have to be careful. Make sure you give him plausible deniability.
Exactly. That's exactly true. That's why I did this one myself, and I didn't have him do anything with it.
Yeah, then he can go in there and say, Judge, you got to bail me out. I got the bad grandma as a client. She's going to clean my plows.
I have a friend in Texas, and she has had a, what would you call it, a notice to cure or a notice, a notice.
A notice and opportunity. Is it a foreclosure case?
Yeah. But she got it like 6 years ago or 5 years ago, and it's past the statute of limitations. So she filed a quiet
notice of
in the court.
acceleration and notice of intent to foreclose. And under Texas law, that marks the tolling of the statute of limitations.
Well, it's beyond that now. She filed her quiet title, and then she sent out, when she filed the quiet title, she did it against the servicer who was giving her beans. So she never got a response from the servicer, so she filled out motion for default judgment and took that to the court. And she said that on Thursdays they're supposed to be able to sign all the orders, but she went to the court building into another office where there was another judge, and they refused to have anything to do with it. Then she went into another judge down the hall, and he wouldn't sign it. So I told her, I said, well, maybe it's because it's not the judge assigned to the case. Well, she was going to go in there yesterday morning. She went in to get the thing signed, and lo and behold, he was called out sick. And now it's been over 20 days since they've had...
Okay, he might have legitimately already been sick. That's why he wasn't there, but... that sounds iffy. What court was she in? I remember her getting that email from her. Is she in Dallas or Fort Worth?
Denton County.
Denton County. Ooh. I know all those guys up there.
Well,
I sued them for $11 million once.
Well, maybe you can do something for her,
Okay, I will talk to her. I will call up the court from Rule of Law Radio. Maybe I can get Ken to call from Mockingbird Films. And we hear that a judge is calling in sick, hiding from a litigant so that he doesn't have to sign a default judgment against a lender because the judge has been bought and paid for. And I wanted to come down and do a 10-minute YouTube interview. We got Scott next. Maybe we'll get Scott to come down there because he's done the YouTube interview, YouTube video things.
Oh, that sounds fun.
I've done this before. I called Minneapolis, and said that I understand that a judge is trying to kill a woman in court by forcing her to represent herself against her rich husband in a divorce case, and while she's in chemotherapy and sick with cancer. And the clerk said, well, I don't think that's happening. I said, who cares? It's going to make a great story. The next Monday, the judge, he wouldn't give him a continuance so she could get a lawyer. The next Monday, he walks into the courtroom. They said he stormed in, grabbed the gavel, and said, 60-day continuance. When you come back, have a lawyer. Bam! And he stormed out of the court. So this kind of thing works. And if I do it, they'll know who I am.
Yeah.
So okay, this could be a lot of fun. Have her send me another email and bring me up to date. And I'll do some calling Monday. And I am stirring up so much stink here right now that I've got all of these JPs and judges on edge. So I'm filing against everybody. I just filed first-degree felony, aggravated assault against my judge, just for being a smart mouth. I filed against the Texas Ranger and the director of the Department of Public Safety. That's in the hands of a grand jury as we speak. And I'm going after the federal judge in the state. I'm going to file against the federal judge with the state grand jury. So I'm really kind of stirring things up. It'd be a real good time for me to sting Denton County again.
Randy, could you tell our listeners exactly what is plausible? You mentioned something about to Leslie. Did you give your attorney a plausible denial? What exactly? Could you
plausible?
That?
Yeah, plausible deniability.
Okay.
You don't know something. Keeps him in the dark.
Yeah. So, what do you want me to do, Judge? You can't blame me. I got this unruly client over here. When you go into court, you can think of the court like a four-sided chessboard.
Okay.
You're sitting at the table. To your right is your lawyer. To your left is opposing counsel. Across from you is the judge. Now, you have a relationship with your lawyer. Your lawyer has a relationship with you. He has a relationship with opposing counsel because they're across from each other all the time. Sometimes they work together. He has a relationship with the judge because he's in front of him all the time. You're the odd man out. If you're going to win your case, you have to get into these relationships. And the way to use these relationships is you kick your lawyer in the seat of his pants, or you give him reason to believe you're going to kick him in the seat of his pants. Like, if you don't do what I tell you to, I'm going to bar grieve you out of business.
Okay.
Yeah. Now he goes to the judge and say, Judge, you got to help me out here. I got this no good rotten client who's going to kick my behind. You need to cut me some slack in this one, and I'll pay you back in the next one.
Gotcha.
Now, that may not be right, but that's how it works in the world we live in. If you don't give your lawyer plausible deniability, the judge is going to be all over him.
Okay.
So we always want to, if we have a lawyer, we want to protect him. Now, he doesn't always like it. I had one, they appointed me a lawyer on a case in Austin when the DPS smashed me into a building and broke one of my teeth after I'd called 911 on them. And he told me 20 times, if he told me once, you're going to get me disbarred. And they dismissed my case to protect my lawyer from me.
Wow.
That's plausible deniability. And that's in the section on how to handle your lawyer.
Okay.
Hang on, Miss Leslie. We're about to go break. Scott, I see you there. Irvin, Nevada, we'll get to both of you. Scott, we have some stuff for you anyway. We will pick this up on the other side. You want to bring us out? No, it's too late. I've run up out all the time. Randy Kelton, Vet Pack, Rooted Law Radio. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again.
Welcome back to Rule of Law Radio with Randy Kelton, Vet Pack, and we are listening to Leslie from Pennsylvania. Leslie, I believe you have one more question left. Let's go ahead and hear that so we can get on with our other listeners.
Oh, no, you've answered all my questions, and if Randy will help our friend in Denton County, that will be a hoot.
That's great. Yeah, I'm sure he will.
Yeah, I'll have fun with that. When I sued Denton County, it was a hoot. I sued my worst nightmare. The county judge, in the minutes, when they were assigning the district attorney to represent the county, he said, "Who is this my worst nightmare?" And the lawyer said, "Well, apparently someone introduced himself to Mr. Kelton as his worst nightmare." And the judge said, "Yes, and I have a bone to pick with him." Oh, that was great fun. I dismissed the case because the lawyer got all of the litigants to lie to the court. And I told the judge that I filed this case to correct something that was wrong, not to harm any of these litigants. This lawyer over here convinced all of these litigants to lie to the court. And if I pursue this, I'll have to pursue them for aggravated perjury. And I gave a promise to one of the litigants that I would not allow this to harm her. So I dismissed the case. I'll go back and get them later. Okay. Thank you, Miss Leslie.
Okay, thank you. Bye-bye.
Okay, Vet, you want to bring in Scott from Texas. I've got him unmuted, and that could be dangerous.
It always is.
Hello, Scott.
Scott, how are you doing?
I'm doing well. Well, what I wanted to talk about is go ahead and getting started on the lawsuit with the city of Addison. So I have, I have all the timeline and everything put together. Well, it's been together for a while now. And I'm just kind of wanting to, you had said to go ahead and present a tort letter first, correct?
Yes, that is a requirement. This is kind of universal around the country. It is a state requirement. But every state has the same requirement. Is before you can sue a governmental agency or a public official, you must give them notice and opportunity by way of a tort letter, and you must give them at least 60 days to respond.
Okay.
So what I generally do when I construct a tort letter is I literally write up the suit I intend to file. I started off with a statement of the case, a brief statement of the case, and then a statement of facts and a statement of factual accusation or argument in support. And then I list out all of the causes of action. And then I put in the prayer and ask the judge for what I want them to give me as an ending, as an end result. Okay, so I got my lawsuit. Then I take the court heading off the top and put a business letter heading on the top. I take out this section that says plaintiffs and defendants and the section on jurisdiction. I take that off the top of it. So it starts out with a brief statement of the case and then goes to a statement of facts. And then at the end, I take the prayer and change it for a demand to make me whole. And in there, what I had in the prayer tells them, this is what I want to make me whole. And it ends with, make me whole or be sued. Send it to him. When the lawyer gets it, it's not just a business letter, huffing and puffing and griping and groaning. He's looking at a lawsuit. So when you tell him, make me whole or be sued, he's going to tell the mayor, this guy's not kidding. He's already got it written. And they will always either ignore it or deny it. Because they believe they will always be protected. So, how do we craft a suit that sticks? One way is subject matter jurisdiction. You have to get them out from under their immunity. And when you accuse them at each step of violating law, that takes them outside of scope. Primary case on that's out of El Paso. A sheriff's deputy picks up a 19-year-old woman from one jail and is transporting her to another jail and decides on a little recreation in between. He stops and rapes her on the way to the second jail. Well, she sued, and the officer claimed immunity, and the judge said that rape is not within scope. He claimed that he was on duty acting in his official capacity. And as long as you're acting within the scope of your official capacity, you're immune from suit if you're a police officer. And he said rape is not within scope. Essentially, committing crimes is not within scope. No one is authorized to do that. And there is no immunity from criminal behavior. At least no legal immunity. So, you've already filed complaints against these guys. Criminal complaints.
Correct.
And you'll be filing criminal complaints against the judge for not acting on the criminal complaints. Now you back up and show a pattern of criminal conduct. And that goes to RICO. When you have two or more people perpetrating predicate acts in furtherance of an ongoing criminal conspiracy, that's what amounts to RICO. I had an Oklahoma judge tell me once that when you file a RICO suit, it's like dropping an atomic bomb. Terrifies everybody, especially when you're claiming very specific criminal acts. I have a case in Decatur, and I've been extremely careful. This is a perfect case because I was pulled over about 2 a.m. after I dropped my wife off at work and given a ticket because my registration was expired. And it was expired for 6 months. I went to I had to sign the ticket and agreed to appear before the court on or before the 12th day of May. So a couple of days later, I went to the court and asked to see a magistrate. Well, we don't have a magistrate here. Well, get me one. I want to see one. Oh, we can't find one. There's none here. So, well, I come here to see a magistrate. They didn't know what I was doing. But in order to when you sign the citation, they are only authorized to release you on a promise to appear not just before a court of jurisdiction, but before a magistrate with jurisdiction in the county where the offense has occurred. Magistrate, not a judge. So I went to appear before a magistrate, didn't show up. And then I filed a couple of information requests requesting certification of officers, authorizing them to enforce the traffic code. And the chief of police I know personally, he is really doing a chicken dance. He's a pretty big guy. He's fun to watch doing a chicken dance. Rex Hoskins, I've known him a long time, and he's really dancing trying to find a way to show authority to enforce, but I got all the code in front of him. So this I'm leading up to charging them criminally when they've done nothing mean or malicious. And that's a good part about this one. Everybody's been very professional. They're just following policy. So this one will be interesting to see how it shakes out. You have more mean and malicious stuff. Hang on. Randy Kelton, Vet Pack, Blue Bell Radio. I call in number 512-646-1984. We'll be right back.
With all the immigrants begging to come to America, you'd think people who are born here would be counting their lucky stars. So why then are record numbers of Americans renouncing their U.S. citizenship? I'm Dr. Catherine Albrecht, back with the answer next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Last year, 1,800 Americans living overseas renounced their citizenship, a record number. Do these folks just hate our country? No, but they're fed up with burdensome tax laws. Most countries don't force citizens living abroad to pay federal taxes, but the U.S. does. In fact, since 2004, the government has hit Americans living overseas with steep fines and criminal charges, even forcing them to disclose information on spouses who are foreign nationals. It's high time the U.S. got off the backs of Americans living overseas, and come to think of it, the rest of ours too. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
You are listening to Rule of Law Radio with Randy Kelton and Vet Pack. Scott, actually, I have a question for you. You've been taking on a case with speed and speed limit signs, and I wanted to know, how do you go about...
Hold on, Vet. Before you ask that, explain the conversation we had on the break about this DPS officer you talked to.
Okay. So I just, in conversation, happened to be friends with a state trooper and asked him, there's speed limit, signs out there. And I'm sure that you as a state trooper know the laws and the codes better than maybe a normal, city trooper, what have you. And I wanted to know, have you ever heard of the commerce driving speed limit being more commerce only? And he said, no, I've never heard of that code. And that has never been brought up around me. I've never heard of that. So I wanted to know, since Scott, you've gone through this, where has it gotten you taking it to court?
Well, first off, let's just clarify what the actual law says for speed signs. And I'll read it because I have the book. 201.904, speed signs. The department shall erect and maintain on the highways and roads of this state appropriate signs that show the maximum lawful speed for commercial motor vehicles, truck tractors, truck trailers, truck semi-trailers, and motor vehicles engaged in the business of transporting passengers for compensation or hire, a.k.a. buses. Now, where does it say a person's car or truck? It does not state that at all. It's strictly commercial vehicles. So, Mr. Officer, can you please tell me the year, make, model, and the color of the bus I was driving for you to pull me over for allegedly speeding and violating that posted speed sign?
Wait, hold on. Another question you need to ask. Where in law is the state authorized to erect speed limit signs that apply to non-commercial traffic? That's the question you need to ask. Because he's going to say, this doesn't apply just to commercial traffic. This applies to everybody. So, okay, I see where you have authority to erect signs for commercial traffic. Where do you have authority to erect signs for non-commercial traffic? Does that make sense, Scott?
Well, yeah, I agree with it because I know it pretty well. So that's, it's just a thing, though. You can't educate the cop on the side of the road or you get your window smashed in. Trust me.
Okay, hold on. This was 601.904?
201.904.
Okay, good.
So, anyhow,
Go ahead, Scott.
Talk, Scott. I'm choking here.
I'm trying to. Okay, gotcha. So, but anyhow, that's what we are. The officers need to. They are supposed to know the law, and it's their job to know what this book says and to go.
Wait. Hold on, Scott. Explain why they're screwed if they don't.
Because if they don't know the law, then they shouldn't be out there enforcing the law.
No, I was referring to. I actually found a citation that you put in on Screws v. U.S.
Oh, well, yeah. Let's see.
Okay, here's what it says. It says, okay, this is a 1943 case, Mississippi. Two guys, a sheriff and two deputies in a bar drinking. They're upset at this black guy. They're going to go arrest him. The bartender tries to talk him out of it. They won't be dissuaded. They arrest the guy, wind up beating him to death on the courthouse steps. They're prosecuted criminally. They're sued in the state, and then they're sued in the Fed. Well, they came into the Fed court and said that they didn't have adequate notice that they could be sued in the Fed as well as the state. And apparently the Supreme was not in a very good mood that day because they said that a private citizen cannot claim, it said, while a private citizen cannot claim ignorance of the law as a defense to prosecution, a public official is held to a much higher standard. I wish I had the citation in front of me. It said, while the anyway, at the end it says, if a public official violates a ruling of this court and he be sane, he may not be heard to say he knows not what he does. Now that says that not only must they know the law, the statutes, they must know the case law that applies to those statutes. If not, they're screwed. Okay, go ahead, Scott. I interrupted you again.
No. So anyhow, well, let's just getting back to the tort letter. So then I get the tort letter filed, and I just kind of need to get a little bit of guidance on putting that together, and after that, it'll just be the typical game on how that goes.
This is how the best way to think about it. Okay. We pretty well know that we're going to get ruled against in the trial court. You always go in expecting the trial court to rule against you out of hand at every turn. So your purpose in the trial court is putting the facts and the law on the record. Okay. But it's not just setting the record. You have to understand the politics of the Court of Appeals. They have a different agenda than the trial court does. The trial court, he tries to adjudicate this case and get rid of it. Court of Appeals, they do something else altogether. Court of Appeals, they have to maintain the stare decisis, the corpus juris, the body of law, the case law as it applies to the body of law. You want to look for decisions that you want to ask them to make, where if they rule against you, they create stare decisis. They create case law that other lawyers can use. So you want it so that if they rule against you, they undermine the corpus juris. They create a situation where a shyster can take their ruling and really screw up the jurisprudence. Not just anything you can find where they violate a law or a rule, but something where they will have to rule against a primary function of the judicial system, like due process. Due process is the best because due process comes down to the state from the Fed. And if the judge fails to follow the rules and in the process denies you in a right, that's a procedural due process violation for which you can sue him, but it's also a crime. So look for the ones that would be the most onerous for the Court of Appeals to rule against you. Does that make sense, Scott?
Yes.
Okay. You've already figured out that you're going to get more things to file complaints about than you can keep up with.
Oh, good gosh. Yeah, I can't. I've got like complaints coming out my ears.
Yeah, so that's never a problem. When we start out, we're trying to find a complaint to file. That's easy. You're going to get lots of them. The trick is sorting through all of the plethora of complaints and picking out the ones that point directly to the claim you want to make and support your underlying claim. And I'm looking at the traffic courts are merely a fund-generating engine. They're an income source. And the government is forbidden to do that. But the municipal courts use this to generate an unauthorized tax. And then from there, you show how they violate all these laws in order to put people in a position to where the only thing they can do is pay the fine. Hang on, about to go to break. You want to bring us out, Beth?
Sure. You're listening to Rule of Law Radio. This is Randy Kelton, Vet Pack. Please call us at 512-646-1984.
We'll be right back.
Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. Do good and good will follow you. Yeah, little Jerry, sing reality. Okay, karma's lurking around the corner. Sing, Jerry, come.
As we sow, so shall we reap.
Rule of Law Radio. This is Randy Kelton, Vet Pack, and we are talking with Scott right now. Okay, Scott, go ahead.
So pretty much all I can say is I just kind of get the tort letter put together and then run through that system. I've never been to an appeals court or anything, so it's going to be it's kind of seem like a new experience.
Okay, Scott. Scott, do you play chess?
Yes, I have.
Okay, get out your chessboard. This is not checkers. This is not where you just go after them because you can. Consider your intended end result. Where is the worst corner you can push them into? Now, back up, and what pawn moves do you need to make to herd them toward that corner? This is actually the most fun part about a suit. It's the strategy. We'll spend some more time on this because I actually need to get this constructed myself. I've been wanting to build a standard set of lawsuits we could file in traffic. And one of the things you want to prepare is a malpractice suit against the opposing counsel, against the prosecutor. All these guys are lawyers. They come and do this part-time because they're not the sharpest knife in the drawer. They're not making enough money as a lawyer. So they got to do this part-time job here. You start stinging their bar cards. Make them crazy. You grieve him and then file a malpractice suit. He don't have malpractice insurance anymore. So we want to put together a malpractice suit for the prosecutor and a lawsuit against the municipality. You sue the mayor, actually. But how do we back them in a corner? It's all about the money. And if we show that they're not just haphazardly breaking these laws, but they have carefully constructed this procedure in order to facilitate the collection of fines. When the vast majority of the people come into the court, they do not fall under the statutory scheme. Then you file it as a private attorney general suit. Are you familiar with what that is, Scott?
Negative.
Okay. Private attorney general suit. There are guys out there saying they want to be a private attorney general. No. They don't understand. The private attorney general suit is a name the courts gave to a certain kind of suit that they authorized. Where there's something going on where people are being harmed or abused, but the amount of the harm or abuse is so small that it's not worth trying to adjudicate the issue because it costs so much to prosecute a lawsuit. So they authorized suits where one person could stand up in the capacity of a private attorney general to adjudicate this issue for himself and everyone else similarly situated. And then he could make the claim for everybody else and then collect on the claim to pay for the litigation. So that's what you want to look at. We want to see how much money the municipality collects in a given year, and there's a report they have to give to the DPS on that. I think the worst one was Venus, Texas. They got like 1,300 people, and they collected over $1 billion a year in traffic fines. Absolutely outrageous. So you want them to look at you're shutting down their economic engine. In the end, it's all about the politics. So how do we craft our accusations so that it points toward an ongoing criminal conspiracy to deprive people of due process for the purpose of manipulating them into waiving their rights and paying the fine? That's a basis for a strategy. What do you need to establish in order to be able to show that? And once we've got the parameters, the elements of the case, now we back up and see how we can establish those. What I'm doing here in Decatur is I'm establishing the jurisdiction issue. That's why I gave them these 2 information requests. I sent them, give them the information request. They go to the police because I'm asking for the certification of the police under 701.00 something and 601.001 that authorize it. It goes through the whole section on who can enforce the traffic code. Well, absolutely they cannot enforce, not what's in the transportation code. So he's not going to be able to provide me with those documents. That's a pawn move. Because when I get to court, and I challenge subject matter jurisdiction, they start their blah, 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 and I'll show, well, I'll ask this officer about his certification, and I'll go through the code. And they're going to say they enforce some other code. Well, show that one to me. I can't find it. Okay, what else can we set them up on, Scott?
Well, then that would be, shoot, they got like false imprisonment charges. That's pretty much the gist of it. So, I mean, the case is going to be just have to get put together on what you kind of think is best on some of this stuff, because I'm kind of a little bit lost on some of it.
I know I kind of threw you a curve there, but the point of all this is if we're going to go after them, we need to really get after them. I'm a combat veteran. There's something about combat that changes your perspective. When you're in combat, you don't just get in a fight because you can. You don't start a fight just because you can win. Because even if you win, you use up resources and dilute your abilities in the future. So you have to craft what you do very carefully. You certainly don't start a fight you can't win, because you only get to do that once. And then you're out of business. So you have to be real careful about what you do. So I kind of think of it that way. How do we craft our battle plan? And that we'll be working on. I've got a lot of it already together. One of the things I want to go after is a bailiff. The bailiff is there to keep the peace, but he has been manipulated into an enforcement arm for this ongoing criminal conspiracy. And his problem is he's prominently displaying a deadly weapon. Since he carries one all the time, he gets used to it and he forgets how big a deal it is. Well, the legislature did not forget. That's why they passed 2202B2A that made it a first-degree felony. If he exerts a proportionate exerting authority he doesn't have and commits simple assault by offensive speech or offensive touching while prominently displaying that deadly weapon, that's a first-degree felony. Big, big deal, 20 to life. They forget about that part. And they get the bailiff to do that all the time. Bailiffs have to be really, really careful talking to me. If they say anything that I can construe as a threat in order to prevent me from adjudicating my rights, that's witness tampering. That's witness tampering while prominently displaying a deadly weapon. Anyway, just trying to get you focused in a direction. So by next week, think about this. Look at what's happened to you from the perspective of not just what they're doing to me, but what are they doing to everybody in order to manipulate them into just paying the fine, because that's what they want. Vast majority of people just write a check. They don't question. And everything they do is to get you to write a check. So that's my story, and I'm sticking to it.
Well, I'm tell you what, that's going to be perfect for Lake Dallas, because the bailiff, when he kicked me out of the courtroom, and I had to call 911 on the Lake Dallas courthouse, so they let me see the judge. They changed their attitude after the second time I called 911. So the bailiff's got a real problem there.
So, okay, start thinking about, you've been into a number of courts here. Look at what they're doing that is consistent. So if you've got 2 or 3 courts and you can show a consistent pattern of behavior where they're committing predicate acts toward an ongoing criminal conspiracy, what's that called, Scott?
Criminal conspiracy. I mean, shoot, they fall under RICO then, don't they?
Exactly. And if when predicate acts toward ongoing conspiracy, that defines RICO. So that's what we look for. We look for all of these different things that they're doing that on the surface look like seemingly minor adjustments toward administrative convenience and adjudicative expediency. But when you put them all together, paints a really ugly story. Okay. Do you have anything else for Scott?
No, sir. I'll just talk to you later on then, and y'all have a good evening.
Okay, we got to go. We're about to go to break. Thank you, Scott. Randy Kelton, Vet Pack. We'll be right back.